Hi, hello everybody. Welcome to our real estate exam prep, and thank all of you that are online right now live. And the way we're gonna do that, we're gonna go through some sample questions. I think hopefully will be very similar to some of the questions you'll see on the state exam. And we want to just break them down. And this is, so we're not just trying to figure out the answer to a question here. I'm going to go through these questions and try to break them down so that hopefully by the time we complete the breaking down, you'll understand how to decide what or figure out what's the best answer, which is the one we should go with. Because I got to tell you, those on that when you get to take the state exam, which means you've already completed your licensing course, you've passed that. There's no reason you should have trouble passing the state exam, right? I'm convinced, or at least students that I've taught, I'm convinced that when you sit down and take the state exam, if you do not pass it the first time, it's not because you don't know the material. You know the material. What we have to get used to is how to answer these questions and the way they ask the questions. It can create some confusion, and so that's why we want to break down these questions as we go through it. Instead of just showing you the answer, I want to make sure we understand why the wrong answer is not the right answer. Okay, so let's take a look at question number one. Which of the following is a physical characteristic of land? And then obviously we have our options: indestructibility, scarcity, permanence of investment, and situs. Well, if you recall, now there's quite a few characteristics of land. Some of them are considered physical characteristics, while others are considered economic characteristics. And you need to know both of those. You need to know the physical characteristics and you need to know the economic characteristics. Right now, they're asking which one is a physical characteristic. Well, right off the bat, C and D, I think we can eliminate. Permanence of investment, that's got nothing to do with a characteristic of land. Neither does situs at all. Those are things that are got nothing to do with this. Now, so we're kind of left with A and or B. Indestructibility and scarcity. Well, let's look at B first. Scarcity. Is land considered scarce? And hopefully, and I see most of you put no, it's not. Land is not scarce. And I'm going to tell you, you could get a question like that by itself on the exam. Is land scarce? No, it is not. Land is not scarce. Make sure you get that. Now, where people get hung up, they might be looking to live in a particular neighborhood or somewhere downtown where land could be scarce. There are certain areas where land might be scarce, where there's no more lots available in this subdivision to build a house. That makes it scarce pretty much. But we're talking about land in its totality, across the country, United States. And I will tell you, believe it or not, there's more land that's not occupied than occupied. So look, land is not scarce. So that is not a physical characteristic of land. Scarcity is not. Indestructibility is. Remember, the physical characteristics of land. Land is fixed, it is immovable, and it's indestructible. And excuse me. In fact, I'm seeing some comments now, as I knew we would get, because we usually do. Well, you can move land. Well, not if you understand what land is. And this is what you want to be careful. We want to make sure you don't confuse land with dirt. Okay, that's not what we're not. Yes, you can move dirt, you can move topsoil, you can do all that stuff, but that's not land. Land, by definition, obviously be the surface of the land, the dirt, if you will, but it includes the subsurface all the way down to the center of the earth. It also includes airspace above your land. Well, is there any way you're going to move that when you understand what land is? And obviously the answer is no, you're not going to move that, not going to happen. But physical characteristic, the answer we're looking for here would be A. It is indestructible. Very good. All right, let's look at the next one. Number 2. The owner of a life estate in property, and then we got to figure out which would go with this statement. First of all, make sure we understand we're dealing with a life estate. And you notice it says the owner of a life estate. Now, owner, I will tell you on the state exam, they could use the word owner, but another term they frequently will use is the term life tenant. The owner of a life estate is also called a life tenant. So just be aware of that if they should use that term on the exam. But anyway, if you own a life estate, that means you own it. If you're the life tenant, you're the owner of that property. The only difference is how long you own it, right? When I say difference, the difference between owning it as a life estate versus, say, a fee simple estate. As the life estate means you own it for as long as you live, right? But now after you die, you no longer own any interest in that property, meaning could you decide to leave it to your heirs or to give it to somebody else or what? No, because you no longer own any interest to give to somebody else the moment you die. It will automatically go over, once the owner dies, it automatically rolls over to whoever the remainder man is, whoever was named in the estate as remainder man. That's the person that would have remainder interest. That person will then own the property when the owner or the life tenant dies, right? So just make sure we're clear there. So let's look at our answers here. You do not have to pay real estate taxes, is entitled to possession of the property, may not receive income from the property, is not responsible for all the repairs to the property. Now, again, if you're thinking about this, if you're the owner of the property, even though it's a life estate, you're the owner. Let's just break them down here. Will you have to pay real estate taxes if you own real estate? Yes. Just because it's a life estate does not mean the taxes are not paid. And guess who's going to pay it? The owner, or the life tenant is considered the owner. So that one would not work. B says is entitled to possession of the property. Well, if you own the property, should you be allowed to stay here? Should you have possession of the property? Absolutely. I like that answer. If you own it, you certainly have possession. But let's look at the other two real quick. C says you may not receive income. Well, that's not true. If there's some way that this property will generate income, you own the property, then you own the income that comes with it. No problem there. And then D, not responsible for repairs to the property. Well, then who's going to make them? Who do you think is going to make all the repairs to that property if the owner doesn't? Well, who's responsible, rather? Let me put it that way. The person responsible is the owner. So that's not true. That won't work. So I think the right answer would be B. The owner is entitled to possession of the property. Yeah, and I hope you're seeing by breaking these things down will help you so much. If you just break them down and think about this a little bit, that's all you got to do. All right. This next question, well, let's read the question. 3 individuals own a motel as tenants in common. One of the individuals decides to sell all of her assets. She may legally, and then we got to figure out which of these things may she legally do. Well, couple things we have got to make sure we understand before we can even begin to try to answer questions like this. There's a big difference between tenants in common and joint tenancy, right? We've got to make sure you understand that difference. Be careful. You got to make sure you understand this. This is where I see most people have problems with questions like this. They get joint tenancy and tenants in common confused. So let me just give you a couple bullet points about each one of them, because you got to keep them straight. Obviously, tenant in common or joint tenancy implies multiple owners, or at least more than one, at least two or more owners. Because if you only had one owner, then you're talking about tenancy and severalty, right? Severalty means one. So any other type of tenancy other than severalty would suggest more than one owner. Okay. So in this case, there are three owners of this motel as tenants in common. Well, if you're tenants in common, number one, you need to make sure you know the interest can be divided unequally. You do not have to, each owner does not have to have an equal share of interest. Now they can. All three owners may own equal shares. They can do that. But the key is they don't have to. For example, one of the owners might own 50% of the property. The other two only own 25% apiece, right? Well, how would you know how much interest each owner has? Well, you look on the title, because under tenants in common, each owner will get their own title, which will reflect how much interest each owner owns. So if I was one of the owners, I'd have my title and my other partners would have their title, each reflecting the percentage of interest they own in the property. Now, if you're joint tenants, which is not what the question's asking, and I get that, but it's important to make sure you can distinguish between these two, or you're going to have problems with the questions. If it's joint tenancy, almost the exact opposite will apply from what I just said about tenant common. As joint tenants, you cannot divide the property unequally. Cannot do it. In fact, the way it works is there's only going to be one title as joint tenants. And then in this case, all three names would be listed on the title, and it will show that all three own the whole property. That's important because, again, you cannot divide up the interest unequally with joint tenancy. And you also know that I said there's only going to be one title. There's only going to be one title here. And when you do joint tenancy, there must be special wording. And in fact, I will tell you, they like to use that terminology on the state exam. Which of the following tenancies would require special wording? Joint tenancy. And the wording they're referring to here is that it must state that ownership comes with the right of survivorship. I lost my train of thought there for a second. But anyway, the special wording is that it must come with the right of survivorship, meaning under joint tenancy, if one owner dies, then the remaining owners now own all of it themselves. In other words, if you're the owner of a joint tenancy, you cannot do anything with your interest. You can't leave it to your heirs. In fact, you couldn't even sell it or give it to somebody without the other owner's permission. Okay. Now there are some remedies to that. I'm not going to get into all that right now. But if I was a tenant common, we each have our own title. Now, could I decide to do whatever I want to do with my interest? I could leave it to my heirs. I could sell it. I could do whatever I want because I have my own title. They're not on my title. The other owners are not, but joint tenancy, they are. Okay, so if you remember those pointers about each one of them, that'll make it a whole lot easier trying to answer some of these questions. All right, so let's figure out. So the question is, she may legally, and let's figure out which one. A, sell, because the tenant in common may sell her portion of assets if a majority of the co-owners also agree to sell. Well, based on what I just said, if you're a tenant common, does her ability to sell require the other owners to approve of it? No. Joint tenancy, they would, but not under tenancy in common. All right, so B, not sell, because the tenant common's interest always remains encumbered. That's not true. We just talked about that. If I'm a tenant common, I can sell it if I want to. So B is not the right answer. C, sell, because the tenant common has an an undivided interest in real property that is transferable. That sounds exactly like what we were just talking about. They can sell their interest. Now, obviously, they can't sell the whole property, but they can sell their interest, which is what they're referring to here. But then D, not sell, because there's a right of survivorship. Remember, we talked about that. The right of survivorship only applies to joint tenancy, not tenant in common. So hopefully you agree with me that the right answer would be C. The owner can sell the property. Okay, very good, very good. Okay, moving on to number 4. Which of the following statements is false? Now, you would think this should be a pretty easy, I mean, how hard can this be? That suggests 3 of these options are right or correct statements. One of them is not. We got to figure out which one is not. So let's take a look at it. A, fixtures that are purchased, paid for, and installed after the execution of a mortgage are subject to liens of the mortgage. Excuse me. I don't know why I'm coughing today, and I apologize for that. But anyway, in other words, we've closed on the house, right? There's a lien on the house. There's a mortgage because they borrowed money from the bank, obviously. Are any fixtures, now first of all, what are fixtures? Fixtures are anything that is attached to or planted on the premises, on the property, okay? So if you've attached anything, it's now a fit, like say you got bookshelves that you've attached to the wall. That is considered a fixture. Well, is that fixture now subject to the mortgage that's on the house? Yes, right? Because that's now the property is certainly subject to that lien, and anything that you attach to it now becomes subject to that same lien. So that would be a true statement. B, when a landowner tears down a fence with the intention that it may be permanently removed and piles the material on the land, such material is real property. Now, y'all think about this one. It says there's a fence around the property they've now torn down. And they took all the pieces, all the fence that they tore down, and just piled it up somewhere here on the property. And they're suggesting that that pile of trash is now considered real property. Does that sound true to you? No, it's a pile of trash. Again, what is real property? Anything attached to or planted on the premises. We've got a pile of trash just sitting on top of the ground here. Does that attach or planted? No, so B does not sound like a true statement. So that might be a good answer there, but let's look at the others. Generally, trade fixtures that are installed by tenants are personal property. Again, now here they're talking about trade fixtures. Now remember, there's a difference between trade fixtures and fixtures. by definition, a trade fixture is personal property, but it's attached to real property by a tenant that is leasing that space and being used for their business or trade. Now, y'all, I tell you, I get so many people start asking, well, if I rent my house out to so-and-so and they attach this, is it now mine or whatever? Or can they do that? And look, we're not talking about, a trade fixture is only for tenants leasing what I would consider to be a commercial space, because they have to use it for their business or trade. This is not for residential use here. Okay, if it's residential use, then it's not a trade fixture. So keep that in mind. It's a trade fixture, which is personal property, which means even though that tenant has attached it to the property they're actually leasing, once they attach it, does that now become the ownership of the owner, or does the tenant still own whatever it is they attached? And the answer is that the tenant does, because it's considered personal property. Now, I will say this: if say the lease is getting ready to expire, and the tenant has no desire to renew the lease, they plan on moving or whatever, if you want to take that trade fixture, whatever that was you attached to the property, if you want to take that with you, then you have to remove it, unattach it, obviously repair any damage that may have been caused. You got to do that. But all that has to be completed prior to the lease expiring. Okay? Because once that lease expires, if you allow it to expire, anything attached at that point now becomes ownership of the property owner. But while the lease is in effect, it's just considered a trade fixture, and they can remove it as long as they repair damages and take it with them. So again, see, trade fixtures that were installed by the tenant are personal property. That's a true statement. And then D, hot water heater installed on the property becomes a fixture. Yeah, y'all, you attach the hot water heater. Okay, that's a fixture. So that's a true statement. So the best answer here, I think we decided, was B, the pile of trash. When you tear down that fence, pile it up, that is not considered real property. What is it considered? Trash. That's what I consider it. So anyway, moving on. Number 5, specific liens would not include which of the following? Well, again, obviously we're talking about liens here, but there are different types of liens. Remember, some liens are considered specific liens, while there are other liens that are considered general liens. And you got to make sure you don't confuse the two, because really that's what they're asking here. Specific liens would not include which of the following, which suggests that 3 of those would have to be a specific lien. One of them is not. One of them would be a general lien. Okay. Remember, a specific lien only attaches itself to a single piece of property, a specific piece of property. Where if it's a general lien, that affects everything you own. In other words, if you owe somebody money and they file and get, let's say, a judgment against you, that affect, they can come after everything you own, both real and personal property, to make sure they get what's due to them. So anyway, let's look at these liens: mortgage liens, judgments, real estate taxes, and mechanics liens. 3 of those obviously are specific liens. One of them is not. Well, a mortgage lien, does that affect, when you borrow money and sign that mortgage, are you putting everything you own up as collateral? No, just that piece of property. So that's a specific lien. And I just gave the answer away a little bit earlier, obviously. A judgment, if you have a judgment against you, that's the general lien. That affects everything you own. So if the courts order you to pay whatever amount to whoever is suing you for it, that becomes a judgment. And if you don't write them a check for it, they now have the right to come and take everything you own to satisfy that debt, or at least enough to satisfy the debt. But real estate taxes, y'all, it's only that one specific property. Mechanics liens is one specific property. In fact, I'll also tell you, first of all, what's a mechanics lien? Okay, a lot of people I find get confused here. But when if you have a contractor come up, let's just say you have your roof replaced. You get a roofer to come out, they replace the roof, and now for whatever reason, the owner does not pay or has not paid the contractor for the new roof. Well, obviously, if the roofer does not get payment, can they just take the roof back? No, they can't do that. So what they'll do a lot of times, they will file what we call a mechanics lien. That becomes an encumbrance on the property. So why would they do that? Why would they file a mechanics lien? What purpose would that serve? Well, because that lien is an encumbrance, that means you cannot do anything with the property. You can't sell it. You can't give it away. You cannot transfer this property to anybody else. Now, a mechanics lien is generally it's a temporary lien. So it will actually expire and go away after a fairly short amount of time. But what the contractor is trying to do here, they're just trying to tie the property up for a short period of time, which will hopefully buy them enough time to get you in the courtroom, basically sue you for not paying for that roof, and then get a judgment from the judge. Remember now once they get that judgment, now that becomes a general lien, which basically puts everything you own at risk until you pay this contractor, right? So anyway, that's what contractors do. If they have not been paid, they file a mechanics lien, even though it's a temporary lien, but it's there to temporarily encumber the property so that you cannot do anything with it until they get you into court. Okay. All right. So I think the right answer here would be B, the judgment. That's the right answer. Going on to number 6, a farmer purchased land with no access to a street or public way. After an unsuccessful attempt to gain access through negotiation, he was able to gain access through a, well, first of all, let's make sure we understand this. If you own land in this country, if you own land by law, you cannot be denied access to your land, period. Now, is it possible that some may own property and there's just no way to get to the property? There's no public access, there's no road or whatever. So there's no way to get to the property without crossing over somebody else's property. That's what we're dealing with here. The farmer owns land with no access. There's no way to get to it without crossing over somebody else's property. But then it says, after an unsuccessful attempt to gain access. In other words, he talked to some of the other owners that were adjacent to his property, trying to get permission, basically to have an easement granted to them so that they could legally cross over their land to be able to get to their land, the owner's property, right? And nobody would give him permission. They said, nope, you ain't coming on my land. Not going to happen. Not here. Nope. So now what do? Well, again, by law, they cannot be denied access. So the only recourse is to go to court. Then we'll let the courts decide. And they will decide where this easement is going to go. Now, first of all, make sure you know what an easement is. An easement is the legal right of one or somebody to be able to cross over somebody else's land for some purpose or for some reason. Okay. So that's what we're looking for here. But what type of easement? And you see there are 4 types or 4 options that we could decide to go with. could have an easement pertinent, easement in gross, easement by necessity, or easement by prescription. Well, an easement appurtenant, now first of all, the term appurtenant just means any rights that currently exist with the property would convey from one owner to the next. In other words, it's deeded. So that easement would be part of the deed and it conveys from one owner to the next. Well, obviously, there's nothing in this farmer's deed that gives him access to that land. So there's no way that would not be an easement appurtenant. He did not gain access through an appurtenant. Didn't happen that way. Easement in gross. That's when another owner gives you permission. And now easement gross, it could be in writing, but it doesn't have to be. It could be a verbal agreement that you could just cross over to whatever you need to do to get to your property. Well, it says in the question that didn't happen. Nobody gave him permission. So easement gross would not be the right answer. Then the next one is easement by necessity. That one looks promising. Y'all, easement by necessity would be granted when someone owns land that is landlocked. There's no other way to get to the land without crossing over somebody else's land. And to get that, again, that would require you to take some legal action for the courts to determine where this easement will be, because we need the easement out of necessity, right? So C appears to be the right answer to me, easement by necessity. But then the last one is easement by prescription. And just to make sure you understand it, y'all, prescription means the easement was created when the owner of a property allowed someone to cross over their land. Now, they may not, in fact, most likely never gave permission. I never told them they could cross over my land to do whatever it is they're doing. The problem is I never did anything to stop it either. I didn't try to stop it, but I never gave them permission. Well, if you allow someone to continue crossing over your property and you take no action to terminate it, if they're allowed to do it for a long enough period of time, then they can now claim an easement, which means a legal right to cross over by prescription. The fact that you never tried to stop me from doing it, now you can't stop me from doing it. That's what an easement by prescription is really dealing with. All right, so I think, again, the right answer is by necessity. Very good, very good. All right, y'all, hopefully this is helping you out a little bit, but let's do a few more. Number 7, a woman built a fence that extended beyond the boundary of her property onto her neighbor's property. This would be an example of, is that an encumbrance, adverse possession, encroachment, or an easement? Well, an encumbrance. Remember, an encumbrance is anything that would render your property unmarketable. Now, I will tell you, if the fence that was built here, in fact, just to be clear, y'all, says there was a woman built a fence, maybe thought the property line was in one spot, so they built the fence according to where they thought the property line was, and now they find the property line's not where they thought it was. And as it turns out, now they actually built the fence across the line, which encroaches onto their neighbor's property. Well, that's not an encumbrance, right? B, adverse possession. No. Y'all, what is adverse possession? Adverse possession basically is when someone, when they know this is not my property, I do not own it, but I'm going to help myself to it. And if they're allowed to stay there for some extended period of time, again, don't worry about how much time it is. That varies from time and place and whatever. But anyway, if they're allowed to stay there, no one tries to get rid of them, then eventually they could claim ownership of the property via adverse possession. Well, that's not what this lady's doing, because she thought the line was in one area and finds out later it was actually in another, it was somewhere else, which resulted in the fence being built across the property line. So that's not what we're dealing with at all. C is an encroachment, and that's exactly what you're encroaching on your neighbor's property. So if you build a shed and part of it extends beyond the property line onto your neighbor's property, that's an encroachment. The fence, that's an encroachment, which is what I think we're dealing with here. And then D is an easement. Well, obviously we just got through talking about easements, and that's got nothing to do with the question at all, right? So I think the right answer is an encroachment. Well, I don't have the slide. The answer is encroachment. Okay, I apologize. I don't know what happened to that slide, but the answer is C, encroachment. And I will tell you that will have to be fixed. They'll have to remove that fence, put it back on their property. Because remember, an encroachment by definition is an unlawful infringement onto one person's property by someone else. So, and the key word unlawful, which means it's illegal. So that will have to be rectified. They'll have to remove that fence and repair any damage they cause to their neighbor's property. All right. So let's look at number 8. An elderly woman owned a life estate measured by her own life in residence. She leased the property for 5 years using a standard lease contract. Shortly thereafter, she died. The lease was, so obviously, again, we're talking about a life estate, and we're talking about something, an elderly woman, which was the owner of the life estate. She decided to lease it out. So apparently she decided to move somewhere else and then rent the property out and signed a 5-year lease. So let's see what's the right answer. A, it is valid only as long as she was alive. B, valid for the 5 years. C, invalid because she, as owner of a life estate, cannot lease property. And D, valid for up to 1 year after her death. All right, let's break them down. In fact, let's start at the bottom and work our way up on this one. D, valid for up to 1 year after death. No. Remember we said earlier, one of the earlier questions, we said if you own the life estate, you own it for as long as you're alive. The second you die, I say that you, the owner of the life estate, when they die, you no longer have any interest. So anything that you did terminates at the point you die. Okay? Nothing, because now who owns the property when you die? The remainder man. And the remainder man may not want any of that. So anything that they put into place, such as a lease, would in fact terminate upon the death of the owner of the life estate. So that 1 year after death, wrong answer. That's not it. C, invalid because she, as the owner of a life estate, cannot lease the property. Well, again, that's not true either. Because if you own it, you can do pretty much anything you want to do with it while you own it, right? So can she lease the property to somebody else? Absolutely, she can. No problem at all. The only key is whoever leases it, I don't care that they agreed to a term, in this case, 5 years. They both need to understand that lease is only valid as long as the owner of the life estate is still alive. Because the moment that person dies, that lease would be expired. B, valid for 5 years. Cannot guarantee that. What happens if the owner dies in 3 years? Then that lease would be up in 3 years. It's not valid necessarily for 5 years. But then A, valid only as long as she was alive, which is what we've been saying and talking about. So I'd say A is the right answer. 8 is A. Very good. Then number 9, an electrician did some rewiring in a home for which he has not yet been paid. 1 month after the work was completed, the electrician drove by the home to discover a for sale sign on the property. The electrician should file a mechanic's lien, offer to purchase the house, obtain injunctive relief, or sue the listing broker. Now, y'all, I hope this should be pretty simple right here. In fact, we talked about pretty much all the things you need to understand here in an earlier question, quite frankly. But again, let's start at the bottom and work our way up. Can they sue the listing broker? Yeah, I guess you could. Yeah, again, anybody can sue anybody for anything, apparently, but what's the likelihood you're going to be successful by suing the listing broker? No, the owner asked for this work to be done, not the listing broker, right? So the listing broker is not going to be responsible for payment here. Which now I will say, now if the agent actually called the electrician, say on behalf of the owner, and asked him to come out and do this work, agent, you've now put yourself in the hot seat. So just as a side note, you want to be careful about stuff like that. I know a lot of agents do this. They think they're helping their client, but I'm telling you, you're putting yourself in some very liable situations when you start doing things that the client needs to do on their own. Okay, because if that client does not pay for it, that electrician, guess who that electrician is going to call? You, because you called me to fix it. Now, you owe me the money. Now, if they want to pay it, that's fine, but you owe me the money because you're the one requested the service. But that's not what it says here. So the listing broker is not liable. Obtain an injunctive relief. No, that's not happening. Offer to purchase the house. Never seen that happen before. People say, but they could. Okay, yeah, they could. But given this question and these answers, which one is the best answer? And then A, the last one here, file a mechanic's lien. Y'all, that's exactly what we were talking about earlier. So if the contract does work that has not been paid for, they need to file the mechanic's lien, right? That's what encumbers the property so that they know they can't sell it. And obviously, if you see the for sale sign in the yard, they're now trying to sell this property. That's pretty clear. And I haven't been paid. Well, guess what? I'm not going to let you sell this property until I get paid. I'm going to file this mechanic lien. That'll stop that, which is what we're doing. So the best answer here, obviously, would be A. All right, and then number 10, included among the legal requirements of taking title to real property as tenants in common. Again, we broke that down. I think that was like the first question we talked about so far. Remember the difference between tenant in common and joint tenancy. But again, we're talking about tenants in common. Again, included among the legal requirements of taking title to real property as tenants in common is ownership interest must be equal. Is that true for tenants in common? No, it is true if it were joint tenants. Remember, tenants in common, it does not have to be equal shares of interest. All right. B, each owner's interest may be conveyed separately. Remember, we said as tenants in common, each owner will have their own title reflecting the amount of interest they own. That is conveying interest separately. So B sounds like a good possibility here. C, a co-owner cannot will his interest in property. Well, if I own this, say 50% of the property, I'm a 50% owner as tenant in common. Can I leave my share, my interest to my wife when I die? Yes, you can will your interest to your heirs. So C is not the right answer. Now, if it were joint tenancy, I could not do that, right? Because joint tenancy is the right of survivorship, not with tenant in common. And then D, the last survivor owns the property in severalty. Again, not with tenant in common. That would be true of joint tenancy, but not tenant common. So I think obviously the best answer would be B. Each co-owner's interest may be conveyed separately. Okay. Look, y'all have done very, very well. Because I see where you're marking some of your answers, and most of you are doing really well here. I hope you find these were helpful and some of the explanations to be helpful. But we're going to call it quits for now, but we're going to have more. So you'll see more of these popping up. So feel free to join us whenever you can. And we certainly hope everyone has a marvelous rest of the day.